Good morning and welcome to today's webinar. Today's topic is how to uphold the Bank Secrecy Act, keeping safeguards in effect. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Madison Cummins and I'm today's webinar organizer. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed at the conclusion of the presentation. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the slides will be sent to all attendees. You will also be receiving a certificate for training for this webinar, or for attending this webinar in its entirety. Lastly, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Last thing before we get to our presenter, I have to share a legal notice for webinars. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. The presenters advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Waltman, Weinberg & Reese. All right, now for the moment everyone's been waiting for. I would like to introduce today's presenter, Matt Young. Matt is a shareholder who works out of our Cleveland office and is the firm's credit union group leader. Matt represents credit union clients in Ohio and across the US in this role on a broad spectrum of legal and regulatory issues. Acting as general counsel, he advises on labor and employment, trust and estate, and litigation and title dispute matters. He also performs regular transactional work, including contract review and negotiation, and counsels on commercial paper and check issues and other collection matters. Matt is a frequent presenter and a trainer on many key issues impacting credit unions, including fraud policy and prevention, consumer collection strategies, and today's topic, the Bank Secrecy Act. Without further ado, I will now hand it over to Matt.
Good morning, everybody, and thank you for attending today's training session. Most all of you are familiar with BSA, I imagine, and as such, we tend to do this regularly, at least annually for most. And as a result, I go through these materials at a somewhat quick clip. I'm mindful that we're kind of coming up on the lunch hour, so I will move through this material, like I said, relatively quickly. I believe this concepts that we will go through today are certainly going to be the type that are very familiar to you. And if you do have questions, certainly feel free to use the Q&A feature, but also that's part of this presentation, but also feel free to just contact me. Sometimes that's the easiest thing to do. And I'm always happy to take phone calls or emails if you have about this or anything else for that matter. My contact information is on the last slide of today's presentation. So if you don't feel like addressing the question now, or if things come to you kind of after you leave today's presentation, you say, I meant to ask that. Again, feel free to shoot me an email or a telephone call and we can go over your question. So with that, let's get into the meat of our presentation. So today we're going to be talking, as I said, about the Bank Secrecy Act, including the goals of the Bank Secrecy Act, minimum requirements for the financial industry, money laundering, which is the greatest source of SAR filings that you'll see when we go through today's materials, customer identification program, record keeping requirements, and the types of reports that you will have to file to be legally compliant and stay out of trouble. Briefly about our firm, we are the largest collection law firm in the country and really represent nearly every type of creditor, including some of the largest national banks in the country, and address topics that run the gamut, including bankruptcy, consumer and commercial collections, litigation, probate, real estate default matters, and of course, a core to what I do is what I call corporate counsel work for credit unions, and that it can include employment law matters, trust and account setup matters, anything essentially that your credit union runs into. That's a legal issue. That's pretty much my day-to-day handling. So, and I've carved that niche over the last approximately 20 years here at the firm, representing exclusively the good folks that are credit unions. We operate with extremely high compliance standards. We have a robust compliance department with the managing partner is on top of these things. Has a significant reputation in that regard. And so you can learn more about all of this at our website, weltman.com. Okay, on to today's program. We're talking about the Bank Secrecy Act, originally known as the Currency and Foreign Transactions Reporting Act, or the Anti-Money Laundering Law. Nobody calls it any of those things. It's BSA that we all know it by, and it's an old law. It was passed in 1970, so it's certainly not new. It was passed with the goal of government agencies being able to get information from financial institutions to detect and prevent money laundering. BSA's goal is to reduce illicit financial threats by ensuring that there are systems, procedures, and programs in place to protect against these threats. To aid in that goal, part of BSA's focus is to ensure record keeping in a format that can be transmitted to the government to deter and prosecute crime. The Code of Federal Regulations implements the Bank Secrecy Act and requires all credit unions to establish compliance programs. As a credit union, you must have internal controls to ensure ongoing compliance, including independent testing and auditing by credit union personnel or third parties. You must address ongoing training and designate a compliance officer. And this could be in a smaller credit union, a CEO, or a hired compliance officer overseeing all compliance matters, or maybe even a team, depending on how large your organization is. These folks will be ultimately the parties responsible for filing SARs and CTRs, suspicious activity reports, and currency transaction reports, which we're going to discuss here in a minute in some detail. One key to BSA compliance is to ensure that this training is done at the time of initial hiring and also through periodic training such as today's. Testing should review overall compliance, but also you want to review individual reporting systems, including SARs, CTRs, and other reporting instruments. As smaller financial institutions, less complex testing is probably necessary as opposed to a larger national bank, and that makes common sense for a variety of reasons. The key is to ensure that the data is captured, conveyed to the compliance officer, and then the compliance officer completes the appropriate report. So again, you want to capture it, you want to convey it, and you want to report it. Now, money laundering is the most common basis upon which a suspicious activity report is filed. And in fact, SARs can be filed for a lot of reasons, but of those, more than 50% are due to money laundering activity. And so we want to review this on a high level just so you have the basics of this so you can be on the lookout for it. The first of 3 steps in money laundering process is placement. And this is the most vulnerable stage of the money laundering process And its key is to getting ill-gotten gains into the financial system without attracting any attention. This may be done by a number of ways. Some common techniques include structuring deposits, which we will go into in a little bit of detail shortly, depositing large amounts of currency for less conspicuous sums, purchasing different monetary instruments that are collected and then deposited into accounts at other locations of the financial institution or at a different financial institution. So that's the most risky stage and the first stage, placement. Second stage we have involves layering, and this basically involves moving the money around. What we're trying to do is the perpetrator, the wrongdoer, is trying to do is to create confusion and complicate the paper trail. Common techniques to look for are exchanging monetary instruments for larger or smaller amounts, or wiring or transferring funds through numerous accounts in one or more financial institution. Wiring, I will point out to you, is something that should serve as a bit of a red flag to credit unions. And the reason for that is that wiring procedures, at least are perceived to be, and I'm not saying this is necessarily the case, but they are at least perceived to be a little easier to facilitate wiring with less sophisticated requirements at a credit union. So if a wrongdoer is going to engage in money laundering and using wiring as the process, your credit union might be a primary focus, thinking they can get away with the wiring in this layering process, whereas they may not be so successful for doing so in a large national bank, let's say, by comparison. So if something doesn't look right, especially on a wire, that always should be a yellow, maybe red flag, and definitely we want to be looking at a second pair of eyes on it and asking questions and looking at such things as how long has this account been open? Is this a unique kind of thing for this account? That sort of thing. Because if it looks suspicious, and as of late, I'm running into these, if it looks suspicious, it is suspicious. Finally, and the third stage is integration, and that's the ultimate goal of money laundering. It creates the appearance of legality occurring from the previous two stages, right? That we move the money around. And so now you have this money that's washed, quote unquote, and we're going to use it for something. We're going to buy, let's say, a commercial building. Those are expensive, maybe $3 million, $5 million, whatever the number is, right? You buy it, you fix it up, you do whatever you do with it, and then you sell it. People do it all the time. Most of them, hopefully, are doing it legally. But you sell the building, and now you have $5 million in your pocket, and you go and deposit that money. Completely legitimate transaction. Voila, you have now cleaned that money. You have a basis to have it, $3 million, high-level money laundering example. So you got the placement, the layering, and the integration, and you see it roughly there. Okay, so this, as I said, is the most common basis for a suspicious activity report to be filed, which is why we want to kind of walk you through what that looks like, money laundering. Next, I want to talk to you about customer identification programs. And of course, in credit union parlance, we don't want to say customer. There are our member identification program. So it should be a MIP as opposed to a SIP. And you'll pardon me if I use these interchangeably, but we understand the concept. We're talking about our members, and the customer requirement, member requirement is the same nonetheless. The key focus of a member identification program is that there is a need to verify members are who they say they are, so the credit union can form a reasonable belief as to the identity of that member. A customer identification program must identify procedures for opening an account, including identifying the information needed from each prospective member, which at a minimum includes the following. One, their name, of course, their date of birth for an individual, the address at which they should be located, which most commonly should be the residential address. If it's not, we already got a yellow flag, right? So why don't you have a residential address? Perfectly have an explanation, but definitely want to get to the bottom of that. I mean, if they're in the military, it makes sense. But once you start moving into a more suspicious response, this yellow flag may turn into a red one. And fourth, we need to obtain their tax identification number for U.S. individuals. Most U.S. individuals have a tax number. It's called their Social Security number. And that is what we would expect to see for most. But that's not always the case. We certainly have some friends on the line, I'm sure, that cater to the Amish population. And my understanding is they oftentimes don't have a Social Security number. So we would certainly accept a tax ID number. And certainly for those, the other question that often comes up is, what if they don't live in this country? Well, your customer identification program, member identification program, should contemplate this. So is a passport number and country of issuance acceptable? Hopefully we'll find that in that program detail. So you want to look into that. Typically they do. Obviously you want whatever they're presenting to you to bear a photograph so that you can verify their image. Okay. When we talk about non-documentary methods, this for purposes of verification, this is particularly important where, for a number of reasons, but in my mind, where they're opening accounts online. And by the way, fraudsters love to do that because they don't have to come into the credit union and show their face. And so if you open accounts online, which more and more credit unions certainly are doing, you just have to be mindful that you're more probable or more likely opening up yourself to potential fraud, and you'll want to address that perhaps even more aggressively. So you need to have non-documentary methods to verify a member's identity. And this could include contacting the member, independently verifying the member's identity, comparing the information from the information they provided to consumer reporting agencies, public database, or other source. Checking references with other financial institutions is great. Obtaining financial statements, things of that sort. Because of the challenges non-documentary methods can present, you must have procedures that address circumstances that increase the risk that the true identity of the member cannot be verified based upon the documents presented. Well, that makes enough sense. So therefore, your member identification program must also address situations where you are unable to ID the prospective member. And if that happens, the policy needs to consider terms under which the member may use the account while the credit union attempts to verify the member's identity, and when an account should be closed after those attempts to verify a member's identity have failed. And then also when a suspicious activity report should be filed. And of course, we've talked about the time frame, that should be no less than within 30 days of the account's closure, because 30 days is the magic number for that. Moving on to record keeping. Customer identification programs must address record keeping. You want to be sure to keep all documents, supported documents through this process for 5 years. And that time frame is the same for all topics and all documents that we're discussing today. A member identification program must address record keeping that at a minimum provides all information about a member obtained, a description of the documents relied upon, the type, ID, number on the docs, and the place of the document's issuance, the methods and the results of any verification, and a description of a resolution of any discrepancy, if any. You must compare information. Let's see here. It's not advancing for me. All right. You must compare information with government listed known terrorists, and you must make a determination within a quote unquote reasonable time. Member notice is also a requirement as part of your member or customer identification program. Credit unions must provide members notice that they are using information to verify their identity, and that can be done in a number of ways. And certainly those on the phone here likely know how that's done because they're seeing these signs every day. A lobby sign with that information is typically posted. Oftentimes you will also see these signs on each teller station just in case, and likely the member didn't notice it when they walked in on the basic lobby sign. If you're opening accounts online, you would typically see that kind of a disclosure in what would be a click wrap type agreement that they acknowledge that they read. Of course, we know they probably didn't, but we followed the law, so we've checked that box. All right. Moving on to suspicious activity reports. And I have a general rule on suspicious activity reports over time. And you'll hear me say this more than once, but when in doubt, file, and you'll see why. Because there's a number of bases upon which to file these reports, but if you don't file them, there are penalties where you should have. If you do file them and you don't have to, there's no penalty. So sometimes I've had examiners say, as a write-up, they shouldn't have filed a report. And then I always have a conversation about that because I think it's an interesting point to bring up. I guess people have to complain about something, and so that's one of them. But typically, we can all come to the same page on filing suspicious activity reports where they've been filed. I don't think there's a lot of pushback there. Okay. So when to file a suspicious activity report? There's a broad basis, as to when you must do this. The type of report that must be filed: if the credit union knows, suspects, or has reason to suspect there's a crime or suspicious activity related to money laundering or a violation of the BSA has occurred. We can come up with some ideas, but that's quite broad. The compliance officer should be notified monthly as to this. If none, I would state none. If you have a credit union that is subject to 1 or 2 a month or 1 every other month, I would affirmatively collect that information. If you're a 1 a year or almost never, then I'm okay with you reporting it just as they come in. But so as to avoid overlooking a report, I would just kind of have that as a standing slot to report to. If you're, again, let's just say if you're reporting more than 4 or 5, 6 a year, just have that as a monthly sweep so that you're not missing anything. There are no SAR requirements for robbery. That is one thing. You certainly don't need to file a SAR for robbery, because guess what? When you're robbed, I'm going to say you're calling the police. So the law enforcement's been notified. So no SAR filings for robbery. The most common types of SARs, and we've kind of alluded to this, right, are money laundering, and that accounts for by far more than half of the SARs that get filed, which is why at the outset of today's presentation I walked you through the money laundering kind of process. And that's, let's say, 50+%. And then and these are in order, by the way. Check fraud comes up next, which, if you look at this list, probably doesn't surprise most of you. And that accounts for roughly 10% of the common type of SAR fraud filing that we're involved with. Everything else, so let's just say 60+, everything else falls, again, in order, but is the remaining 40%, 30%, whatever the number actually ends up being. It's a lesser number. Okay. One thing that I want to point out, and it's imperative not to forget, that SARs are confidential, and you cannot report those to anyone, even if that person is requesting it via a subpoena. And this comes up, and sometimes there is a legitimate basis upon which to request a SAR. But your baseline is, no, we are not providing, we're certainly not disclosing the SAR or its existence to the member against whom we're filing it, or any third party. Now, what the U.S. Attorney's Office has said is, if you get such a report, notify us, and we will handle it. That's fine. They may find the basis is legitimate. And in fact, I've seen this where other U.S. attorneys in other departments request this sort of information, and I bring in the other U.S. attorney and say, your other counterpart here is requesting this, and they will deal with it themselves. It's no problem. But from a high level, don't think because a subpoena, because typically when you get subpoenaed, right, you're expected to respond, and maybe you call the lawyer and check it, or maybe you don't. You say we deal with these, and you just do it. In this case, you don't send any SAR-related information to a requesting party via subpoena without contacting your attorney first. All right. One other point is you're immune from liability for filing a SAR, so there's no concern about defamation or discrimination because you filed this. The government wants to encourage you to do so. And so that goes back to what I said at the outset, which is, when in doubt, file these. And you want to do so for insider abuse of any amount. And I wouldn't get too much caught up into the detail. Basically, like I said, if you have to have a question, file it. But the rules are 5,000 where a suspect can be identified, 25,000 regardless of a potential subject, and 5,000 that involves potential money laundering or BSA violation. So, in terms of, let me see, yeah. So, again, don't get caught up in this detail. Just go ahead and file if you're suspicious. Quite frankly, that's basically my point there. Okay. SAR filing procedures. You have to obtain the forms online, and it's the same site for currency transaction reports, or CTRs, which we're going to discuss in a minute. They must be filed within 30 days after determining the original problem. And if you cannot locate a suspect, you get an additional 30 days for a total of 60 before you have to file. Okay. All SARs and CTRs must be filed electronically on FinCEN's website, and I think this requirement goes back 20 or nearly 20 years. I'm sorry, 10 years ago. Time flies fast, not that fast, but this requirement seemed recent back when I was presenting many years ago, but it's not. So hopefully that makes it easier for you all, and it's an electronic filing process. In dealing with shared branching, theoretically everybody has to file, all parties involved where a SAR needs to be filed. But the fact of the matter is FinCEN does not want multiple reports. Who does, right? Nobody. So the shared branching agreement will address who reports, typically the party, at least in Ohio, who accepted the transaction. And again, just reiterate the confidentiality requirements. You can't disclose it to the party against whom it's being filed. All right, currency transaction reports. CTRs, as we all know them. Currency transaction reports are required for transactions in currency for more than $10,000 or a foreign equivalent shall be reported. And this is appropriate and required for deposits, for withdrawals, for exchange in currency other than payment or transfer by or through or into a credit union. Before conducting a transaction where a CTR is going to be required, you need to get some information with respect to that individual, namely their name, their address, the account number which is involved, and the social security number or taxpayer number that accompanies that person. For deposits, anyone who benefits from the transaction, so we talk about joint account holders here, would benefit because they can access the money, right? So for withdrawals, only the person conducting the transaction, unless other information is known that leads you to believe others will benefit from the transaction. So for example, if a wife withdraws $12,000, doesn't say who it's for, we're going to report the wife. The husband deposits $12,000, we're going to report both. The wife withdraws $12,000 and says it's for a car for her husband, we're going to report both because both can benefit from this. And I think I'm going to switch this next year so that the husband and wife are flip-flopped. This has been the same fact pattern since this presentation's been given. So we are going to mix that one up, I think, for next year. CTR filing procedures. You must file CTR within 15 days of a transaction. As with SARS, we file the CTR on FinCEN's website, and also the retention time to maintain these documents is the same. It's 5 years. So for cash in, cash out transactions, these may be reported on the same CTR if both qualify as reportable transactions. Transactions should not be offset against each other. For example, and we'll go through several, this is a little complex, but it illustrates the point. If a member deposits $11,000 into a savings account and withdraws $3,000 from the checking, the CTR for the savings deposits should be filed, but not for the withdrawal. If the member deposits $6,000 into the savings and withdraws $4,000 from checking and presents $6,500 in US currency exchange for foreign currency, the credit union should file one CTR with more than one entry. Cash-in transactions. The cash-in transaction is reportable for the total of $12,500, which is apprised of the $6,000 deposit and $6,500 presented in foreign currency, presented for currency. And the cash-out transaction is reported for a total of $10,500, the $4,000 withdraw, and the $6,500 return in foreign currency. All right, that was a doozy. Okay, so we're going to talk about aggregation here. People attempting to evade CTR filings, which there are many, or SARS for that matter, may use different methods to do so, such as by performing multiple transactions at multiple bank or credit union branches. And this is essentially structured transaction. And it involves one or more persons engaging in one or more transaction in an effort to evade a CTR filing. And structuring is, of course, illegal. CTRs are not required for certain exempt entities, such as other financial institutions and state and federal agencies. There are also certain other entities that are non-listed businesses who maintain a transaction account, who, if they maintain a transaction account for at least 2 months, frequently engage in transactions in excess of $10,000, and are incorporated or organized under the laws of the U.S., or is registered as an eligible to do business. They can be designated using an exempt person form filing, FinCEN 110. And an example of this would be someone such as a grocery store. And the designation must occur within 30 days of the reportable transactions. Okay. Certain entities are unable to become exempt, likely because they are the type of business that could be used in money laundering, and you can look at the list and see. I won't go through it, but certainly you can say, these would be the type of businesses that money laundering might utilize. And so they're not able to be apply for non-listed business status. Okay. To evade the $10,000 CTR threshold, it is common for money launderers to purchase monetary instruments. And so we want to address that here too. It's required only if daily purchases aggregate $3,000 or more. And if the purchase has a deposit account with the financial institution, you have to obtain the name of the purchaser, the purchase date, the types, the serial numbers, and dollar amounts of each instrument, and verify the identification of the purchaser. You can do that through the signature card for non-members. Examine documents that you normally look at, such as identification, and verify their name and address. Wire transfers in excess of $3,000. And we've talked about this. I mentioned how credit unions tend to be more targeted for wire transfers for suspicious activity because they're viewed as somewhat less restricted, sophisticated entities comparative to maybe a large national bank. So you might be the source of these. So always, look at these with some caution and maybe even a second pair of eyes. So where you have a transfer in excess of $3,000, you need to obtain the name and address of the originator, the amount, the date of the execution date, the payment instructions, and the identity of the beneficiary bank. Okay, on to information sharing. Law enforcement may solicit information from credit unions through FinCEN. This is a written certification by FinCEN, which is a directive from them for you to conduct a one-time search. You must search current accounts or those maintained in the last 12 months for persons being sought, or 6 months for accounts used to facilitate transactions. Periodic match reports to FinCEN, positive matches that report must be provided to FinCEN within 14 days. If there's nothing, no negative response is required. Any information obtained should only be used to respond to FinCEN. This shouldn't involve vigilante credit union activity, following up with a member or anything like that, since they're such bad people. Nothing like that. This is a one-time inquiry. We don't want to put them on a watch list, like I said, or anything else. And it's not a basis for filing a SAR in and of itself. Very, very important, and I'll reiterate this, you do not want to disclose to anyone that FinCEN is requesting this information. Information sharing is encouraged to identify terrorists and money laundering activity. You must notify FinCEN of your intent to share with established procedures, security and confidentiality provisions in there. And then when you renew, FinCEN sends automated emails so you can continue on in that manner the following year. Let's see. Before sharing, be sure to verify with other financial institutions that it's sent to FinCEN. Information received is subject to the same security and confidentiality that you would have. You still cannot share SAR or its existence as part of this voluntary sharing. Okay. Commonly cited violations. I'm not going to go all the way through these, but you can see them. Not providing a risk assessment, a BSA AML risk assessment in any detail. Generally, SARs not being completed correctly. Failing to list all beneficiaries on a CTR, that sort of thing. Like I said, I'm not going through those, but that's for your reference, just so you can see. And the penalties can be significant, and you may have seen that the government is getting a little more strict on this and really hitting people mostly in an egregiously violating BSA's terms, but the fines are significant. And so, and there does seem to be an uptick in enforcement and issuing penalties as of late, in the last 5 years or so. So something to keep in mind as you kind of go through this process. Relative to fraud prevention tips, of course, you want to use diligence to protect and detect fraud transactions. If something doesn't look right, it's not, and I go through these sorts of fact patterns daily with folks, and, they're calling me and they're already suspicious. And once we walk through the process, over 90% of the time, they had very good reason to be, because it's basically a fraud deal. And so, be proud of your instincts. If you think it's, be confident in them. If you think something's not right, it probably isn't. I mean, that really is the way it goes. So, things that we look at is, does the transaction make sense? Did they just open the account? Are they putting large dollar amount transactions in there and then promptly pulling them out or attempting to? Do not be afraid, folks, to put extended holds on those accounts. Reg CC has certain requirements, but what are the consequences of not honoring those? Not much. I mean, I guess you could get an attorney that's going to call and scream and holler. And in that case, that really kind of supports the notion that maybe this really is a legitimate transaction. But the consequence of letting fraudulent money go out, of course, is you're now holding the empty bag, and that's a known dollar. So just keep that in mind. There's the law, and then there's some common sense here as well. And some of that kind of shakes out. But where somebody gets aggressive with you, wants their money right away, those are the kind of things that I put the full brakes on. And, I lock down. People freaking out on me about getting their fraudulent money is not a good starter. And that will just further dig my heels into, you're not getting the money, we're putting an extended hold on. So that's something that's come up recently. It gets presented to me somewhat daily. So if you have those issues, feel free to run those by me. Also, just want to throw this out there. A number of credit unions are dealing with elder abuse issues, and we have elder abuse training. If any of you are interested, this is an affirmative requirement by financial institutions, including credit unions, to report suspected elder abuse. It could be family members, unfortunately, are often the case, or quote unquote friends. But if elder abuse happens and we don't kind of turn a blind eye to it, the credit union could actually have some liability there for funds that are taken out improperly, given this affirmative requirement that we now have. So if you have questions on that or an interest in a presentation along those lines, that's kind of an increasing thing. And we'd be happy to answer any questions or set up a presentation for your credit union on that topic. And with that, I am concluding today's presentation. If you have any questions, let me know. Otherwise, feel free to email or call those questions if you want to relay those later. Thank you for attending.
Thank you for attending today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 30 webinars that you and your team can view on demand. Our collection offers information on a variety of topics such as bankruptcy, real estate, and collateral recovery, to name a few. We'll be sending you a link to the library in our follow-up email. You will also receive a certificate for attending this training. Thank you again for attending, and have a great rest of your day.
Thanks, everybody.